Deputy Laura,
Yes, Judge.
I think that if it's cold outside, many attorneys will show up on time. That's what we need. We need it to be freezing. Although I still can't get over Mejia. He's acting as though it's beyond cold. Deputy Laura, my spam calls are still in full effect. I don't know what else to do.
Put it on do not disturb.
Well, I can't because I'm waiting for calls.
All you have to do is put it just for your contacts, and only your contacts will make it ring.
Ah, okay. So I'm going to figure out how to do that. So just do not disturb for everyone but contacts. All right. I'm going to make that happen. All right, everyone. I'm going to call the docket. When I call the docket, you need to stand and let me know you are here. If you don't respond, I'm going to assume you're not here and a warrant will be issued for your arrest. Custody, we have Angela Redwine, Roger Mims. Thank you. Charles Claycomb, custody. Timothy Gonzalez. Timothy N. Gonzalez. Macedonio Claudio Jr.
Present.
Thank you. Mary Stella Guerrero. Joe Manuel Hernandez. Miles Fenton, custody. Christopher Rivera, Dylan Skinner, April Gonzalez, April Ramirez, Christopher Rivera, custody. Oscar Barrera. Thank you. Jose Ricardo Maciel.
Present with counsel, Judge.
Thank you. Daniel Montoya. Daniel Montoya. I think that person may be by Zoom. Kyle Stone, custody. Thank you. Robert Dale Stevens. Robert Dale Stevens. Thank you. Kendall Tashawn Smith. Kendall Tashawn Smith. Renee, why didn't you pick them up and drive them here?
Cold, I guess. I'll make sure that the cold is.
Are you coming in or out, sir?
All right, thank you. Joseph Garrison, custody. Jeffrey Flores, custody. Jorge Alberto Cuellar Guevara. I did all of those names and they're not here. And I think I may have said them correctly. Christopher Quinn Rivera, custody. Vanessa Portales, thank you. Aaron Joseph Mendez Trevino. I'm going to stop saying all the names. Timothy Zapata, custody. David Jarrett Castro. David Jarrett Castro. Jason Moore, custody. Nilda Cabello. Am I pronouncing the last name correct?
Yes, you are.
And they're not here to see it. Sammy Salazar, custody. Michael Martinez. Larry Smith. Angela Redwine, custody. Jenny Tim. Thank you. Benito Vasquez. David Castro. David Jared Castro. Benito Vasquez. I'm sorry, you're just on the docket more than once. I do believe David Castro, I want to say that's been reset. And I'll double check. Karen San Miguel, custody. Tyler Ashball. Tyler James Ashball, 130. Renee Esparza. Francis Rigby, custody. Cody Cross. How many times are we going to put April Ramirez Gonzalez on the docket? Isaiah Gibson, custody. Thank you. Jacqueline Wallace, Sydney Peterson, custody. Alexandria Alvarez. Thank you. Matthew Baggs, custody. Alejandro Ulysses, custody. Timothy Gonzalez. Daniel Montoya. Thank you. Robert Dale Stevens. Kendall Smith. Jorge Cuellar Guevara. Aaron Joseph Mendez. David Jared Castro.
Here you are.
Second row,
Where?
sir. Second row. Second row.
Second row. Nilda Cabello. All right, everyone. So they tell me it's cold outside. 23 degrees. Is that really that cold? I don't know. Thank you. My thing is usually it's 100 degrees in San Antonio. So just subtract the 23 degrees from 100 and feel the 80-degree weather or close to 80 degrees. These are the rules of the court. Please follow them and things will run smoothly. Number one, we're recessing at 12. So if your paperwork isn't to the clerk, if you're entering an agreement by 11:40, it's not going to happen. You're going to have to come back in the afternoon. Do not bother approaching the coordinator and say, can I come back tomorrow? No, you'll need to be here in the afternoon at 1:30. If you have a client who's in custody, please request them from the deputy. Once you've requested your client, please do not leave the courtroom because we have a limited number of deputies. And for security reasons, that means a limited number of inmates are allowed out. People in the audience, do not talk to people in the box. Do not signal to them. Do not smile at them. Do not try to pick up a date with them. Number one, you shouldn't because they're in custody. I see laughter, but guess what? People have tried to pick up with dates with inmates and inmates have tried to date people in the audience. They only want you to help them with their bond money, so do not do it. If you talk to them, what's going to end up happening, if you're not on the docket, the deputy is going to tap you on the shoulder. You will need to leave the courtroom. Do not try to make any explanations. Just leave the courtroom. You will only be allowed back in this courtroom if you are needed as a witness. If you have a client who wishes to speak to the court in a language other than English, doesn't matter if you speak the language or not, we'll need an interpreter. Just let the court know through the clerk or the coordinator. Do not talk behind the court reporter when we're on the record. You'll know because I will have called the style of the case. If you have a client that you're entering into an agreement with, or if they have a compliance hearing, or if they have a motion to revoke, you need to confer with probation. Probation is sitting right there. Ms. Abrams, could you raise your hand? Guess what? You're going to slow down the process if you don't confer with her, because when you come to me with what you think may or may not be your agreement, the first thing I'm going to ask, well, maybe not the first, maybe the third or fourth thing I'm going to ask is, what does the coordinator, what does the probation officer say? So please confer with them. All right. It's going to be a great day. Make sure that if you have a file here, this is criminal trial division's files, this is family violence. Just put your file on the desk, have a seat. Nobody's trying to catch the flu, pneumonia, or COVID this late in the game. All right, everyone, it's going to be a great Friday Eve. Please confer. Oh, and I'm sorry, attorneys, when you're ready to approach, just talk to the coordinator or the clerk and have them pull your file, have a seat, and I'll call you in the order of appearance.
note that I gave you. He's just here. He was supposed to be on the docket, but I didn't see his name on there, but he has a case setting for him to be here today.
All right,
So, we already pulled a file, but we're not ready yet.
okay, all right, thank you.
I will. I would never fall for that. You're like a mother always.
I know, I need to stop. I want my nails to grow.
Oh, I think I'm here.
And she is.
Oh,
It was definitely.
I agree with that.
It hasn't, oh, it was on, Yes. Yes.
All right, Rendon. If you'll come around this way, please. Do you solemnly swear all this true? Sorry about the wait.
Oh,
Yeah, yeah.
I have not talked to her. Yeah.
Okay. Country.
Yeah. Skinner?
Yes. Good. I'll make them rated later.
It's immune defense.
Just make sure sign before you go. All right, thank you.
Have one day.
You too. Joe Hernandez. Hi, council. How's it going?
Good morning, Judge. How
Good
are you?
morning.
Fine.
All right.
Morning,
Good
sir.
morning. So this is your dismissal.
Thank you.
All right. Have a great day.
Appreciate your time.
All right, you're welcome. And thank you for always dressing appropriately for court.
Yeah, do something with some clothes.
All right, thank you. Have a good day, okay?
Good day.
Absolutely.
I think so, yeah.
When you go out.
Timothy Gonzalez.
It's the first name, last name Thomas. It's said on the docket.
Robert Dale Stevens.
They told me today.
Kendall Smith. Jorge Alberto Cuellar Guevara. Aaron Joseph Mendez Trevino. Nilda Cabello. David Castro.
Well, they talked to you because they had said, hey, I wanted to try to bring it on Tuesday. And they said, no, the earliest would be the 20th. So they did speak to you this. It's 2024 CL 008305.
It's not set to the 27th.
Right. And, yeah, but we had it set today for I filed a motion for it. That's.
I'll have to do it maybe next week. I can do it on the 27th. Do you have a court date or you want to come back twice? I just if you want to Tuesday.
Is there a way that we can approach the judge without just?
He has to be here.
Okay.
Since he's in jail, I have to.
Really, I didn't want to. But, matter of fact, I need to speak to you about.
You would have to approach the judge, you would have to
Okay.
pull the docket from the back.
Okay,
ask
I'll do
for
that.
it, And then come back.
Okay. And then maybe I can forward that on the 7th, because I know the 27th is not gonna be available. Maybe.
It's not a matter of
Oh, I
expectation.
would-
You would have
Let-
to. ask-
Well, it's
Sure.
not a matter of expectation.
Let me hold the file.
Because the warrant said he has people that they're gonna send. They're-
Well, it's not. You're right about that.
Yeah.
I didn't want to vote to vote on.
Hello.
So that's all I can. Yeah, I don't know. Okay, good morning.
Good morning.
I know there's lots going on, or y'all. Many things are, and time constraints today. And the reason I asked you, is I kind of wanted to at least touch base in a couple other towns. Is that okay? What I see what she says.
All right, thank you.
Yeah, I don't mind if she's ready to go forward, but I don't want to try to pin her down.
Oh, yeah, make it easy.
It's safe today.
I downloaded it just.
Yes,
Yes, but I uploaded it.
So we're not gonna end that.
Or take.
We have masks for that.
I don't have the impression.
I have my new earmuffs, you know, my ears have been working, and my ears are fine. Yeah, yeah.
Excuse me, sir. You need to have a seat.
Nothing for that Gennaro Reina that I gave you. 2022. 0496. Because the reason she wants him to get revocation.
I don't, yeah, and I say part of it's good and part of it's not.
Yeah.
Let me see if this case was by chance there.
Yes.
All right, well.
Yeah, it was from a couple weeks ago, but I think they need a trial date on that.
Timothy Gonzalez,
Sure. Yeah. Also this one. There's-
Jorge Cuellar,
Good morning. We're ready to announce on.
Aaron Mendez Trevino, Nilda Cabello, David Castro, all right, Anel Soto Figueroa, Yes.
To get a trial date?
Yes.
Your Honor? So,
Have you conferred with the state on a jury trial date?
yes, Judge, I brought to their attention, basically, whenever the court deems it suitable, we'd be all right with the trial.
All right, Ms. Ferguson, I need a jury trial date. It should take 1 day. So if we were to pick a jury on Wednesday, it should be done on Wednesday. And does your client want a jury trial or bench trial?
A jury trial, Your Honor.
All right. It's criminal trial division.
Judge, I can do the June 10th. Yeah, he'd be there.
That works for the defense, Your Honor.
All right, June 10th.
All right.
And you'll inform your client?
Yes, definitely will, Your Honor.
All right, thank you.
Thank you, Your Honor.
Oh, and counsel, if you'll make sure if that the court has an acknowledgement of discovery.
Okay.
All right,
yes.
thank you.
I'll get it this morning from Mr. Edelman, Your Honor.
Thank you. Norma, this is the file on that one.
Is that the silver case?
Yes. Toby McKee.
Yes, Your Honor, I'm present on that one also.
Yes.
It's a housekeeping matter, Your Honor. This case is not set until the February 24th on Monday.
Mhm.
Wanted to respectfully request if it could be called on the following day on February 25th.
Yes.
I have a conflict as I'm set for, I have a list of jury trial for 99.
All right.
Thank you, Judge.
All right. We'll put it for the 25th.
And I'll definitely let him know as well, Your Honor.
All right. Thank you.
And yes, if I could speak to the judge.
Norma, that's that one.
No, not really. Yeah, it's sent an email on the.
Oh, actually,
Oh.
All right. Who is here on Jose Maciel?
Morning, Judge.
Good morning.
So we have a plea agreement on the case. He's gonna plead to the misdemeanors and we're gonna TIC the felony.
All right. When is that misdemeanor going to take place?
It's set April 3rd, but I can contact the court to get an earlier date.
All right. If you'll contact them to get an earlier date and then let me know what that date is, and then I'll put it on the calendar.
Okay,
All
sounds good.
right.
All right, thank you, Judge.
All right. Thank you.
He's still gonna stay here? Judge?
Yes. Mr. Maciel, just wait until you get your reset form, okay? Thank you. Who's here on Kavant Thomas? Yes.
Judge, I believe, but I was told I had filed a motion to reinstate the bond,
Mhm.
but for some reason he did not get put on your docket today.
Okay.
But we are set on the 27th for, I think, for
Plea deadline.
deadline, plea deadline.
Mhm.
And I was not going to be available on the 27th, and I was
Okay.
wondering if I could call it like the following week. If you have that available.
On what date?
Like March the 6th, I think it's a week later, 1 week later.
All right. He's set for a plea deadline date on the 27th.
Yes,
Let me
ma'am.
see.
Yes, ma'am. And I was just trying to say, I was not gonna be available on the 27th.
Oh, no, I understand. We'll move it, but let me ask you this. So with regards to this reinstatement of bond, was he on a surety bond?
I believe he was, Your Honor, yes.
And has the bondsman requested to be allowed back on the bond?
That I wasn't sure of, Judge, because I know he picked up a new misdemeanor
Okay.
and you had remanded him without bond.
Mm-hmm,
And then you told me, go ahead, file a motion. I did.
mm-hmm.
And I thought we were going to hear that today, but unfortunately he was not brought over, Judge. So I could come in Tuesday of next week. I was told that may be a day to hear the bond issue.
All right. If you want to talk to the coordinator and see if they can have him available by Zoom,
Oh, okay,
but it wouldn't be this morning. It would probably be the afternoon for Zoom.
okay.
So if you want to talk to them and see when that can be scheduled today,
Okay, I can try to see if we can get that done.
we'll see if technology is going to be our friend today.
Ah, okay, Judge.
All right, Jose Messiel. Oh, I'm sorry. I've already called you. Just have a seat. Anyone else ready? Oh, just make sure you. All right, I'm just waiting for it. They haven't given me a file.
Wait, Mom.
Who are you? They haven't presented me with a files.
Ma'am?
All right, Roger Mims. All right. Hi, good morning. So where are we? Because State, did you tender an offer? Okay. And sir, how old are you?
How old am I?
Mhm.
29.
20?
29.
29?
Yes, ma'am.
All right. You know, people never believe people when they say they're 29. They always think they're fudging. We don't believe it. We think you're fudging. When I was 29, people would say, you're just fudging, you know, because people say you hold on to 29 for as long as possible. Yeah. Let me see here.
And then it becomes 39.
Oh, let me just tell you, the years fly by after you hit 29, really after 18.
They really do.
And then you take the long, quick walk to responsibilities.
Yeah,
All right, so I'm gonna set this for March 17th. That's your plea deadline date.
Judge, I will be on vacation.
Ah,
I've
what's
got
your
a-
vacation time?
I think it's the 8th through the 17th. It's on file, but I know it's right in that window. I think the 17th is the last day.
All right, so we'll set this for a plea deadline date. Ms. Ferguson Mims is to come back on March 20th for a plea deadline.
Yes, ma'am.
All right, once you sign the reset form, you are excused. Thank you.
Thank you, Judge.
Thank you. And counsel, before Tochi, before you leave, if y'all can make sure I have an acknowledgement of discovery.
Okay.
All right, thank you.
You have some special magic.
No, I learned something in the law with regard to search warrants, but the target not at the house at the time of the search warrant. They detained her away from the house, searched her. That's where they found most of the contraband. So I'm learning.
Larry Smith.
Yeah, I did not know.
All right, thank you.
What is the case law?
It's US Supreme Court. I have a copy of the case.
I have.
You ever have that situation?
Yes.
I did too.
They cannot. You have to be.
Come on, Judge.
Good morning. So you finished with your trials. You're on the lookout. People want you in trial.
I got sentencing at 1:30 today.
Oh, my gosh.
Yes.
All right. So the last time we were here, there was a cell phone extraction. Where are we on that?
I got her, I got there.
Okay.
We're gonna figure out, and then I followed up again today.
If you can't be today, I understand. We need to bring him in first. Judge, this case is getting pretty darn old.
Oh, it is. Let me just tell you what we're gonna do.
Yes.
Are you available next week, Mr. DeLeon?
I'm always available for the 187th, Judge.
Oh, thank you. What's a good date for you next week?
If the 175th doesn't grab me again,
Mhm.
I mean, I'm happy to come back whenever the court wants next week.
Well, do you want Monday, Tuesday, or Thursday?
I'll be happy with Tuesday.
All right, so we're gonna come back on the 25th. And on the 25th state, if he does not have the cell phone extraction, you'll need to have your officer ready to be subpoenaed to be here on the 25th to explain why there's no extraction. All right, is there anything else?
No, Judge.
All right, thank you.
All righty, thank you, Judge.
All right, do you have any questions, Mr. Smith?
No, ma'am, not that I can think of.
All right, thank you. I'm trying to make sure that your counsel has all of the discovery he's entitled to, okay?
Yes, yes. We want it fast, so next week is pretty good. Okay. All right.
Yes.
Let's have a seat, so we can keep talking. Thank you.
All right, thank you.
And we're on Jose Marcel, we got the plea set up in County Court 14 for March 19th. Yes, ma'am.
What page is Larry Smith on?
He is working and Judge.
All right, thank you.
He's on page 6, I'm sorry. At the end of the document.
Thanks. All right, which client do you have, sir?
Jose Marcel, Judge.
All right, Jose Maciel, if you'll come up.
We got the misdemeanor set for our March 19th, Judge.
Okay. All right, we're going to recall you back on March 20th. Of course, as everything is taken care of, he won't need to be here.
Perfect.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're
Thank you, Judge.
welcome.
Right, I just sent him the link. This is just.
Oh, Jason, if you could take a look at this, and I don't know, I think family violence may be involved in it as well.
Okay, Judge.
Correct.
One last.
It's not the only one. It's not a lot. I'll leave them. Yeah. I'm pretty sure I have these ones. Correct.
All right, court is calling 2024 CR 0127131 State versus Cody Lane Cross. Could I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Morning, Judge Mark Garland for the defendant, Cody Kraus.
And are you Cody Cross? All right, you entered a plea of no contest to count 4 on February 3rd. The state waived counts 1, 2, and 3 without objection. And defense counsel waived a PSI. Is that correct, defense?
Yes, Your Honor.
All right, so we're here for sentencing. According to your plea bargain agreement, the state is proceeding on count 4 only. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $1,500 fine. The state will make no recommendation to your application for community supervision. And the state opposes your application for deferred adjudication. This is run concurrent with 2024 CC 742862. State is taking in consideration 2024 CC 742860 and 2024 AL 004803. And there's to be no contact with the complainant. Defense, do you have any witnesses?
I don't, Your Honor, but an issue that arose at the last date that the court was ready to sentence Mr. Kraus was you had asked me to contact the Durant County, Oklahoma clerk for purposes of trying to find out what was going on up there, and I have some information for the court.
Oh, yes.
So, Your Honor, he's got a one case number with 2 misdemeanor charges in Durant County, Oklahoma. The pending charges up there are driving under the influence of dangerous drugs and possession of dangerous drugs. So again, apparently the way they do it up there is one case number, but 2 counts, so to speak. So I, going further in my conversation with the clerk, again, I know this is hearsay, but having heard no objection, I wanted to tell you that what the clerk represents is that like Texas, she doesn't know if they're going to place a hold on him here and come and get him within 10 days. So I can't make any representations to the court in that regard. If they, just based on my experience for misdemeanors, I generally speaking, I'd find it unusual for one state to go pick up another. But again, that's kind of anecdotal, and I know you know as well as anyone what the likelihood of that is. But in any case, Judge, we're asking that the court grant Mr. Kraus deferred adjudication. And I know that probation has also been applied for and that the state is neutral on our application for probation, but it's our position that if you give him regular probation, then he'll be somewhat hamstrung in terms of his ability to obtain gainful employment because he'll have a felony conviction. So with all due respect, we'd ask that if he has a chance at some sort of community supervision, that it be deferred so he's not addled with the felony conviction if he goes forth and tries to succeed. And just as a reminder for the court, we had a witness named Ms. Regalado, who's here again today, that testified about his time in the foster care system and stuff like that. So he's had a rough go of it. And then finally, I'd ask the court to take notice that his actions have not been without consequence. He's done a lot of days in jail. And so again, we're asking the court to grant him deferred adjudication at this time.
All right, and the court remembers the previous testimony. And correct me if I'm wrong, if my memory is wrong, but I believe the witness testified that the complainant was not supposed to be on the housing. It was just the defendant, and the defendant allowed or requested that the complainant be under his housing so that she and her children would have a place to stay. Is that correct?
Maybe misremembering, but I think it's something along those lines.
All right. All right, state you're opposed.
Yes. The previously stated at the last hearing, the criminal history that he has, in the new charges up in Oklahoma, we feel that deferred adjudication would be inappropriate for this case. We are silent though as to his application for probation.
All right, so this is what the court is wrestling with. but for the fact that this was his housing and the complainant technically was not supposed to be living under his housing voucher, but he took her in because she had children. If that issue wasn't there, you'd be going to prison. It would not be any type of constraint for me as far as sending you to prison. But I have to sort of weigh that. But then on the other hand, I'm weighing it with what I'm reading in the police report. That's an issue for me. Because what I'm reading in the police report is she called saying that you were in violation of your bond and were attempting to break down her door, which is your residence, and that you were just placed in jail for the same thing. And you had the no contact order in place, but you still went over there. So I don't know if you want to address that. And you're telling the officers, it's just a misdemeanor. So do you want to address that for the court? I mean, if you don't have to. I mean, you waived your right to remain silent by entering into this plea. But if you don't want to address it, you don't have to. But that's my concern. My concern is that you knew you were not supposed to be there. You were just released from jail. And it states, upon my arrival, and this is the police, I identified suspect one by asking his name, to which matched the key card, and I placed suspect in handcuffs. Suspect stated he just got out of jail at approximately 1 a.m. and arrived at the location on bus because he just wanted a place to sleep. Suspect stated that the listed location was his home and that he did not know he had a protective order. Suspect, however, contradicted himself by stating he made contact with the witness one, that's Jasmine, through the phone, asking witness one to leave. I explained to suspect that he was not allowed to have any contact with witness one. Suspect stated he did know he had no contact order with witness one while in the back seat of my patrol car. They patted you down for weapons. And while in the back of the patrol car, I gave commands for suspect to move his feet inside the patrol car, which suspect became non-compliant. I informed suspect it would be in his best interest to comply, so he would not catch an additional charge for resisting arrest, search, and transportation. Suspect stated it's just a misdemeanor. And then you proceeded to kick the car door. And then the other problem is, witness stated officers were at the listed location earlier this morning. Witness stated that during that incident, she reported the suspect calling her, threatening to harm her, and suspect stated he was going to show up to the above listed residence. And so there's a police report for that. And then it says you showed up at the above listed residence at approximately 5:55 hours by transportation of the via bus to the residence. Witness then stated prior to Officer Watts and my arrival, suspect was attempting to enter the residence by kicking the door with his foot and hitting the door with a rock. I observed what were shoe marks located on the door near the lower side of the door handle. Witness also stated suspect threw a rock at the door and attempted to throw it at the apartment balcony door, where I observed the rock located on the apartment balcony. So, do you want to say anything?
Your Honor,
You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
so,
All right, and then it says, suspect stated that when he showed up to the residence, he was going to kick witness 2, Christopher Nunn, in the head and stomp on his chest. Suspect then made threats to witness 3, Dylan Moore, stating he was going to catch him and beat him up. All right, what would you like to say?
So with that being said, I know what the paperwork says, Your Honor, and please.
I'm sorry, you need to speak up. I can't hear you.
I know what the paperwork said, and I understand that was who I am, who I was. In these last 5.5 months that I've been incarcerated, I've learned my lesson. I have time to sit down and think. Me and Jasmine have kids together, which are currently in foster care right now.
No,
I understand it.
no, when you say you all have children together that are currently in foster care, your witness testified at the previous hearing that Jasmine needed a place for her and her children to stay. Usually when people say her children, that means that they're not your biological children.
They're my biological children.
They are your biological children? Okay.
I don't know why she said it was like that, but they're my children. Xavier Kraus and Emery Kraus. I just had a baby girl.
All right, that changes thing for the, that changes things for the court then, because I thought this was a complainant who just needed a place to stay with her children. That's the way the testimony was given to me, that they were not your biological children.
It's the mother of my children.
Okay.
We've been together for it would have been 5 years last year in November.
All right, so that means that she should have been under the housing then.
She wasn't under the housing, when she made the statement, calling and, she wasn't there for the first 2 months that I was supposed to get a 2-bedroom, 2-bath, was because I found a week before I got housing, I found out my baby mama was cheating on me.
You mean the mother of your children?
Mother of my children, she was cheating on me. So we broke things off and I went off and got the apartment by myself. I eventually got over it and I forgave her within that 1 month and a half. And I had asked her to come back home because she had my kids out in College Station. And the only reason why I allowed her to come back was because I wanted to be with my kids. My kids are everything to me. They're the reason why I'm not in prison as right now. Because, Your Honor, I should be in prison for a lot more worse things, but I'm not. And because of my children, they have made me to the person I am today. I would, what I'm saying, I would really like the probation because I really have learned my lesson, Your Honor. I really have. This is a very long 5.5 months that I've been incarcerated, and I really, really, really know that I'm not supposed to contact Jasmine, and that won't be an issue.
How long were you in custody before you went to the home trying to kick the door in?
8 days, exactly.
Okay.
And I was still furious because I know for a fact only me and God would know that I didn't do anything to that girl but come home that night from St. Louis from my dad's.
So did you threaten her on the phone?
No, I did not threaten her.
So you stipulated to it.
I threatened Dylan because I told him that he's gonna have to, at that time, he was gonna have to fight with me because he went and because I was allowing him to stay with me. Granted that I have housing that none of them are supposed to be there with me, but I'm risking my house to help others, help him. And
It's a sad situation that you're allowing random people to stay in a house and you have young children.
And it wasn't a random person. It was Mr. Christopher, her brother, his family friend. It was somebody that basically his brother. I never threatened Christopher at all. I actually have him.
No, it's as though no one's looking out for the children. You have a 2-bedroom apartment that the taxpayers are helping you secure. Well, a 1-bedroom apartment that you're having taxpayers help you with. And you have the mother of your children in there. How many children do you have? You have 2 children. You have yourself. I'm assuming there's 1 bathroom. And now you're bringing in random people that the taxpayers didn't agree to pay for.
Your Honor, I have a huge heart.
No, because here's the thing. I don't understand why people get free things through the taxpayers because we're paying for it. And then your free heart is really not free. You're giving what somebody has given to you and paid for, and you're acting as though, it's your money when it's not. When you have these funded places that are funded by the taxpayers, you're not supposed to have everybody living with you. This Dylan person who you're saying is a friend of the mother of your children, you really don't know anything about him. And you're letting him stay in here, this random guy, be around your children. That's not a good parent.
Time we didn't, at the time he was living with us, we didn't have the children.
Oh, where were the children?
With a family friend because we were dealing with a CPS case.
This just keeps getting worse. Any questions?
Just a brief question, Judge. So is, are you right now obligated to perform a CPS service plan? Do you have obligations to CPS so that you can try to maintain your parental rights?
Case right now, the CPS caseworker comes and sees me every month.
Okay. And is that another reason you're asking Judge Boyd to consider probation so that you can perform your service plan?
Mhm.
Okay, pass the witness, Judge.
And where are the children?
The children are with the family friend that was, that they've been in custody with for the past 5 months.
All right, and when you went to go kick down this door or attempted to kick down this door, were the children in?
No, ma'am.
So CPS was already involved. All right. This is what the court is going to do. Court is finding you guilty. This will run concurrent with 2024 CC 742862. Taking consideration 2024 CC 742860, 2024 AL 004803. There should be no contact with Jasmine Nunn, Nunn. And the court will sentence you to 5 years in the prison, give you credit for any time served, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor, may I ask you a question?
Sure.
Why am I going to prison?
Why are you going to prison?
Breaking into my own apartment.
All right, let me explain something to you, and I'm sure your attorney explained it to you. When you have a protective order, in that protective order, it tells you what you're not allowed to do. Usually in a protective order, it will tell you there are certain locations you can't go to. There are certain people you can't be around. I'm sure in your protective order, it states that you were not allowed to be around Jasmine Nunn. You did it anyway. I'm sure in the protective order, it told you were not to go to that location. You did it anyway. That's a court order. When you violate court orders, that's a signal to the court that you're probably not going to abide by conditions of probation. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Counsel, did you go over the Trial Court Certification of Defendant's Rights to Appeal with your attorney?
I did, Judge.
And did he sign that?
He did.
All right, thank you.
Judge, will the court retain jurisdiction for purposes of consideration of shock probation?
Sure.
Yes. We think over, we probably didn't get the licenses.
Yes.
Oh, okay. All right, let me, just 1 second. Isaiah Gibson. Who's the attorney for Isaiah Gibson?
He just stepped out.
He stepped out.
All right, could I see the file on Kavant Thomas, please?
The attorney returns.
And it's a paper file.
Oh, I think I have it. I should have went for it. Sorry. Yes.
You have her occupational license or?
If you can have her come up, just give me the file. Thank you. All right. On Kavant Thomas, counsel, did you speak with the bondsman?
It's not judge, but I did receive some documents from the clerk saying he had filed an affidavit of surety and that was granted by you.
Yes. So the affidavit to surrender surety, so
Yes.
the bond will not be reinstated with this bondsman.
I understand, Judge, but if we could at least have a bond
Have you
set,
conferred with the state on the bond amount?
I have not.
All right, if
But
you
this-
confer with the state,
Sure thing.
thank you.
Thank you.
Who would be on this? It's an aggravated assault with a deadly weapon ×3. Yes. All right. He's going to confer with you on a bond amount.
Okay.
All right, thank you. Jenny Tim. Hello. Hi. So it's the court's understanding that Judge Angelini took this plea. Just one moment. All right, so it's the court's understanding that Judge Angelini took this plea, and Judge Angelini ordered you to have no driving for the rest of your life. What I can tell you is legally, I placed the order what it should be legally, and legally what it is no driving for the duration of your probation. So you're not allowed to drive for the duration of your probation. If you wish to have a petition for occupational driver's license, then Angelini will need to hear that because he's the one who heard your case and ordered that you were not to drive for the rest of your life. So I changed the order to no driving for the duration of your probation based upon Angelini requesting that you not drive at all. So if you would like, what I can do is I can have this heard by Judge Angelini since he's the one who took your plea. Would you like that?
Yes, please.
All right. Ms. Ferguson, can you call Judge Angelini and see when he will be able to hear this occupational license? All right, just have a seat. We'll see if he's in the building today. If he is, he'll be able to hear it.
Judge,
You're welcome.
we just need to also address some additional concerns
Yes,
in regards to the original conditions of probation
yes.
that Judge Angeli put forth. I don't know if you want him to hear those. I know that you've signed a couple of supplemental reports.
Yes.
So one of the conditions was for her to have an ignition interlock on her vehicle. That vehicle is inoperable.
Mhm.
However, she does have the ignition interlock installed on that vehicle. There was a supplemental report submitted indicating, they wanted to try to possibly get her a portable device because her husband primarily used the vehicle that was inoperable, and I think they were thinking about getting it fixed or something to that effect. And then, she did notify me this morning that they're just keeping the ignition interlock on the vehicle that's inoperable. She is able to test on that. However, her husband does have a vehicle that does not have anything installed. So I wanted to bring that to the court's attention so that we can make sure that we're all on the same page, on how you would like to proceed.
Let's have Angelini come in first to address this petitions, this occupational license, because once that's addressed, then I will
Well-
know with regards to the ignition interlock, okay?
Thank
All
you,
right, thank
Judge.
you.
I just didn't want it to slip my mind.
No, I appreciate that.
All right.
So just have a seat. We're going to see if we can get him today.
Yeah, I don't see the seat.
Yeah, yeah, that's what I'm saying.
All right, is the attorney here on Isaiah Gibson?
Can you put Gonzalez?
All right,
up
Mr.
there?
Gibson.
Good morning, Judge.
Good morning. How's it going?
It is going well, a little chilly.
Oh, yeah. But you know, pretty soon it's going to be 100 degrees and everyone is going to complain about it being 100 degrees.
Mhm.
So are you ready to proceed on the motion to revoke?
Your Honor, we are not ready. I have conferred with the state and with probation. I believe we have an agreement in place. The issue is, Mr. Gibson currently has a hold out of Zavala County on another case.
Mhm.
Through talking with probation, I think that what we were wanting to do was just ask the court for a short reset so we can figure out what exactly is happening with that case, before we proceed with this MTR.
All right. And did you confer with the state?
I did, Your Honor.
So how much time are you requesting?
I don't think we need very long, 2 weeks if the court would give us that.
Ms. Ferguson, on this case, if you'll recall this in 2 weeks, please.
Yes,
And it is Isaiah Gibson.
thank you.
Thank you, Judge.
You're welcome.
March 6th, Judge.
March 6th.
All right, we'll bring you back on March 6th.
We just. Okay, no worries. Don't bring it down.
Who's here on April Gonzalez? Good morning.
Probably set. March 6th.
All right. Yes.
Morning, Your Honor.
Good morning.
I'm here on a bond setting for Ms. Ramirez / Gonzalez.
Mhm.
She has two different names.
All right, let's start with this before we get to that. What is happening with the motion to revoke?
So there's a third case that is unindicted, sealed. We don't know, and I'm reluctant to do anything with the MTR, so we know what she's charged with on those. So
I believe it's actually a fifth case, Your
our
Honor.
fifth case, yes, I apologize.
Mhm.
As well as a misdemeanor.
All right, so this is what the court is doing. We're proceeding on these motions to revoke within 10 days, and it's going to be a contested. Either you all are going to do something with it or not. So, Ms. Ferguson, I need a 10-day reset for a contested on the tampering with the government record and the possession case. And then we'll handle your bond issue.
Well, Judge, it doesn't make sense to make a bond issue after we resolve the case
No, no, no. What I'm going to do is, what I said was, this is going to be set
for 10
in
days.
10 days.
Yes, ma'am.
And then now you say you have a bond
Yes, ma'am.
issue, a bond request.
Yes, ma'am.
All right, so let me give you this date and then we'll take up the bond matter. That's
Good enough.
what I said.
March 3rd. Judge.
All right. March 3rd is contested hearing. So state whatever witnesses you need. Now, with regards to bonds, what cases are you requesting bond for?
On the two MTRs.
All right. All right. And I'm sorry, did you file a motion? Or
Yes,
no?
ma'am.
Could I have the motion for the bonds request on April Gonzalez and April Ramirez?
Yes.
It's 2021 CR 8086. And also 2021 CR 8074. I don't see it here. No, no problem. If you, I don't see it in there. I could be missing it. It's been known to happen.
Can I be excused to proceed,
Yes.
Judge Angelini?
Yes.
I'm gonna take the defendant with me.
All right, thank you. Oh, and Norma, do you need the probation officer to go with you? All right. All right, the court is calling DC 2021 CR 8068 and all right, and 2021 CR 8074. State versus April Gonzalez. Could I have parties announced for the record for the state? For the defense?
Matt Stolhansky for the defense.
All right, and are you April Gonzalez and April Ramirez?
Yes, ma'am.
All right, defense has filed a motion to set bond in each of these cause numbers. Have parties had a chance to confer on an appropriate bond amount?
Yes, Your Honor.
And what are you all requesting?
We don't have an agreement exactly since the state and the clause number ending in 8068, the original bond amount was $3,000 and requesting a $6,000 bond. And in the clause ending in 8074, the original bond was $20,000 and we're requesting it be reinstated at the same.
All right, in defense, what are you requesting?
And Your Honor, we were asking for $10,000 each. We can live with the recommendation.
All right, Joe, raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
April Gonzalez.
All right, Ms. Gonzalez, you're currently on probation out of this court. The questions I'm going to ask you are not about the allegations in the motion. It's just for me to set appropriate conditions for you. All right, so have you in the past ever used any controlled substances? Have you in the past ever been diagnosed with any type of mental health issues? Have you ever been placed on any type of medication for any mental health issues? All right. Then in cause number 2021 CR 8068, the court will set your bond at $3,000. And in cause number 2021 CR 8074, court is going to set your bond at $15,000. Could I have a reset form, please? And the court is going to order GPS full waive fees. And I'm going to give you a reset form. You'll need to be back here on March 3rd. Is there anything else from either side with regards to bond?
No, Your Honor.
All right, we can go off the record. All right, counsel, if you'll just have her sign
Yes,
that,
ma'am.
please.
My hair.
And if you need a copy of the orders, they will give it to you in the back.
Yes, ma'am.
Let me just put it in the system.
Move on.
No. Never knows what it's going to. Plus, maybe the first second minus.
All right, and if you can see if they need a copy, if you need a copy of the order.
I'm good with it, Your Honor.
All right,
Thank
thank
you.
you.
Your Honor, then, Mr. Ramirez, Mr. Ramirez. Eric Hernandez on the two new cases.
All right, just give me a moment.
Sure thing.
All right. Who is the person on April Gonzalez for the new cases? Council, have you received all the discovery?
Your Honor, we have received some discovery. I believe it is complete. Because the MTRs are being recalled in 10 days, I'm asking that these also be recalled to the same date as the state is working on a global offer that will likely encompass these MTRs as well.
All right, so we'll recall it for March 3rd.
Thank you, Your Honor.
All right, thank you. Thank you.
Thank you, Your Honor.
You're welcome.
When you receive the call, then you paste it.
Okay, I just before you had to go. No.
You're welcome. Who is here on Stephanie Moorhead? Stephanie Moorhead. Moorhead on the docket? She's not.
The shirts.
All right, that's done. And that's done. Okay.
So she needs to have pictures on all the vehicles,
Okay.
except the one that's work.
All right, can you put that in the notes in Odyssey?
And I'm gonna amend the conditions for her to switch it over.
All right.
And so can you go after that?
Yes.
Okay, then you can release that.
All right, who's here on Jared Castro? David Castro? Yes. Yes.
Yeah.
We're missing a lot of discoveries.
Okay. All right, and where's your client?
Who's in the back?
All right, you have come forward.
I'm sorry.
All right, counsel, you're on this side.
I apologize.
No problem. All right, who's the prosecutor on this? It's family violence, I believe. All right, so it appears that this is the first setting. Does anybody know, is CPS involved in this?
No, Judge.
Okay, so there should not be any CPS records? Okay. All right. So it's a first setting for discovery. So off docket, you all need to confer.
I did, Judge. And I'm gonna tender, we'll file this letter, but this is some of the stuff that we're missing. But it's not an all-inclusive list, but I'll
Alright.
file it with the court.
All right, do you have a copy of this?
We'll send them. I'll make a copy and leave it with them.
All right, so if you'll make a copy of this for them. And then,
And there's one other thing, there's one other item, Your Honor. My understanding is that the complainant in this case has a criminal case pending in Bear County.
mhm.
I would like to file on that.
All right, so if you'll add that to your list.
Yes, Judge.
And as far as the indictment, Deputy Laura can give him the indictment today.
Okay, Judge.
Deputy Laura, do you have the indictment on David Castro? All right, so,
I can fully judge.
all right, so they'll pull a copy of that today, so the indictment will be taken care of.
And what I will do, Judge, just
Mhm.
because when they send stuff to e-discovery,
Mhm.
it is labeled differently than when it comes down to us.
Okay,
So I will provide the court with what we receive and how we receive it.
all right, and so on this, he's asking for sane photos. And I understand there may not be issues with that as far as where you can view those.
That's fine. It's not a child, Judge. It's an adult.
Ah, okay. And I'm sorry, I'm just putting this in the system.
So the court is aware, Your Honor, for the same photos that I saw in the app, specifically request that we'll put something out for those.
All right, thank you.
Thank you.
All right. So I'm gonna bring this back in 45 days.
Okay.
You all should probably have at least had some of the good discovery. Ms. Ferguson, I need a 45-day reset for discovery.
Thank you, Your Honor.
You're welcome. And it's on Castro.
April 7th.
And Your Honor, in regards to the criminal.
You said a criminal,
Last
Case
time
pending?
sure, Judge. Last time we were here on a writ of habeas corpus, I believe Raymond Angelini was sitting for you. I mentioned to the prosecutor at that time that I thought that there was a criminal case pending against the complainant in Bear County. She didn't know anything about it. I have verified that today there is a criminal case pending in Bear County on the complainant.
okay.
And I guess I'm just confused as to what's being asked for us to disclose, or I
What-
did upload a disclosure for the criminal case that was pending.
All right, so if y'all will confer on what specifically you're asking for with regards to that criminal case, if there's an issue and I need to make a ruling, just let me know. All right, so you need to make sure you're on time for court next time. You understand?
He was, Judge, that was my fault. I was talking to him in the hallway and I told her I would bring him briefly to the hallway. My apologies, Judge.
Okay, sure.
I'll make sure she'll be here right at 9 for roll
He.
call. I apologize.
That's okay. All right. Thank you. Thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Yes, ma'am. Thank you, Judge.
You're welcome. Is there anything else?
No, Judge, thank you very much.
All right, thank you.
Gonzalez. May I approach her?
Yes,
You had called out a case that they dismissed.
yes. And I signed the dismissal.
Okay, good. Yeah, she's in custody.
Okay.
But some misdemeanor court appointed lawyer got 2 felonies dismissed for a plea on a misdemeanor. That's a pretty good lawyer.
Well, I have done that previously. Shocker or shocks. And it was when Canales was on the bench. And do you know, he ended up saying, I want to know
Yeah.
why, you know, a felony plea is
Yeah.
being dismissed. I'm like,
Yeah. Well, somebody actually probably read the file.
yes, thank you.
You know, it's amazing what you find out if you read the file.
Yes.
Yeah, just because somebody put an indictment on top of it. Geez.
Exactly. You're welcome. Have a good one. Who is here on Aaron Joseph Mendez Trevino?
And Judge.
Yes. Where is he?
Not sure. I just looked for him. I have to check to see where he's at, Judge. I think he's here.
All right, once he,
Does he show that he checked in? Or
Hmm?
did he answer the
let me see if he
document?
answered the docket. Just 1 second.
His parents checked in with me, he's like a high school kid. So. Okay.
Norma, do you see Aaron Joseph Mendez Trevino?
He's on page 5.
Oh, see, I just ran right past him.
I haven't read the no-show.
Yes, he hasn't shown.
Let me check.
All right, thank you. Are y'all ready on Kavant Thomas?
I do not know that if Mr. Thomas is on your video.
That's him right there.
Okay.
Okay. All right, who's the prosecutor on?
Me.
Oh, okay. All right, court is, if everyone could please whisper, court is calling 2024 CR 008305. State versus Kavant Thomas and counsel. No talking behind the court reporter. If y'all could move that way. Could I have parties announced for the record for the state?
Anthony Miller for Mr. Thomas.
All right, and Mr. Thomas is by Zoom. Any objection to Mr. Thomas appearing by Zoom, state? All right, Mr. Thomas, if you can unmute yourself, please. All right, are you Kavant Thomas?
Yes, ma'am.
All right, do you have any objections to appearing by Zoom?
No, ma'am.
All right, so the defense has filed a motion to reinstate or amend bond conditions. The bondsman filed an affidavit to surrender surety. That is the reason that he is in custody. The previous bond amount was $75,000. State any objection to reinstating the bond amount?
Judge.
All right, a rearrest on what?
Not a rearrest, but a rearrest on this case in WI and my understanding is that he was remanded because he was rearrested for discharging a firearm.
That is correct, Your Honor. Initially, though, the bond was set based on an aggravated robbery, which that is no longer the case. It's now an aggravated assault with a deadly weapon.
Yes.
So we would ask the court if it would please consider keeping the bond at its original amount, Judge.
You're welcome. All right, so.
And just to clarify for the court, Judge, so on the misdemeanor case, he was placed on GPS full house arrest and he was abiding by those conditions once the court remanded him without bond.
All right, so here's the question, because I want it to be clear in my mind. So he's on bond out of this court for the ag assault with a deadly weapon.
Yes.
And then he is arrested for the new case?
That is correct, Judge. He picked up a new misdemeanor case.
And that's for discharging a firearm?
That is correct, Your Honor.
All right. Is there anything else from either side?
Nothing further, Judge.
All right, Mr. Thomas, I muted you because we were getting a lot of noise on your end. But if you can unmute yourself, I just have a few questions to ask you in regards to your bond. All right, can you raise your right hand for me, please? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kavant Thomas.
All right, Mr. Thomas, the questions I'm going to ask you, they're not related to the facts of your case or the alleged facts of your case. And I'm just going to speak to you and ask you questions about past activities. So in the past, have you ever used any type of controlled substance?
No, ma'am.
All right, in the past, have you ever had any mental health evaluations or diagnosis?
No, ma'am.
Have you ever been required to take any type of medication for mental health issues?
No, ma'am.
All right, this is what the court will do. The court is going to set the bond at $75,000. There's to be full GPS. I'll ask that the fees are waived.
Judge, is that, for clarification, Your Honor, is that full house arrest or?
Yes.
Okay. Yeah, we would then ask the court to consider that Mr. Thomas is employed and needs to continue
Once
to
he
work.
brings the court proof of his employment, then the court will reconsider.
Okay. May I be excused?
Just one moment. Ms. Ferguson, on this case, I need a reset date for discovery, please, 30 days. Do you need the cause number? Okay.
It'll be, March
24th. All right, your new court date is going to be March 24th. Do you understand?
Yes, ma'am.
And it'll be at 9 a.m. All
Yes,
right,
ma'am.
thank you. You can let them know that you are finished with your hearing.
Okay, yes, ma'am. Thank you.
All right, thank you.
Thank you very much, Your Honor.
You're welcome. I'm sorry, what? Yes.
Thank you so much for your time.
Is anyone ready on Aaron Joseph Trevino? All right, they're not ready on that one. Who's not here? All right, Benito Vasquez. Yes. All right, just approach when you find him. Jeffrey Flores. Court is calling 2024 CR 012214, State versus Jeffrey Flores. Can I have parties announced for the record? State.
Gary
Defense?
Chirac for the defendant.
And are you Mr. Flores? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Flores, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property, $1,500 with 2 or more previous convictions as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Oh, yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And I'm sorry, just one moment, off the record for a moment. Thank you. All right, did you review the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision. There's to be restitution to the Dollar General store, if any. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There are none, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the Dollar General store. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, no contest. State any evidence.
No objection, Your Honor.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial?
Yes, ma'am.
A right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, if we could go off the record. All right, thank you. All right, thanks. Oh, it happens. Trust me, I've been there. All right, is there any amendments on the indictment for the state?
The clause number, what was it there, then 1-7, the conviction date.
Ending in 7-3?
7-3, correct?
Yes.
April 5th, 2000.
No objection, Your Honor.
All right, do you understand that's a substantive change to the indictment?
Nothing, ma'am.
All right, do you have any objection to proceeding with the state amending the indictment?
No, ma'am.
All right, then the request to, and I'm assuming counsel, you have no objection?
I have no objection,
All
Judge.
right, then the state's request will be granted, and thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, we'll wait PSI, Judge.
Anything you wish to say on behalf of your client?
No, Judge, just the fact he does have new family support. He's married. His wife has been in court every day. That he's been in court. I think she'll do a good job of keeping him in line. And he understands that probation is probably his last chance to avoid going to prison. Is that correct?
All right.
9 years clean and doing good for 9 years. So I've been doing my best, but I did fall off the wagon one time, and I promise that it'll never happen again.
Okay. Great. Do you have any children?
I got one boy,
Age?
5.
Does he live with you?
Yeah.
When's the last time you had employment?
I have employment still. I have my own, I own my own Flores home improvement. So we do anything from home improvements to like lawn to repairs to stuff like that. And I have 4 brothers, and we all work together.
All right, the court is going to find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's a $2,000 fine that will be probated. Restitution, if any, to the Dollar General. And that's the store located at 114 Goliad Road. And there's to be no contact with any Dollar General. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or in the medical field or with minors. Field visits 1 time per month for 6 months. 200 hours of community service restitution. I'm going to order the theft course, CATS 1 and 2. Once he completes that, 100 hours of community service will be deemed satisfied. I'm going to order parenting classes. Once he completes that, the remaining 100 hours will be deemed satisfied. There's to be a TAP evaluation out of custody. Follow TAP recommendations. Probation. Is there anything else? 2 years suspended and probated for 4. All right, is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
It is.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If you have an issue, let probation know. If you feel they're not addressing it, you can always come back to the court. Do you understand?
Thank you so much.
All right, good luck to you.
Thank you so much. Good luck.
Over here.
Yeah.
Tell them I hadn't had a chance to go to the, but I'll take care of it today.
Okay.
Oh, you know what? Yeah, just ask them to leave their number with you.
I have it.
All right, thank you. And tell them I will call them.
Okay.
Thank you. Yes.
Judge, Mr. Mendez Trevino is here. He has an accompanying case in County Court 4. That's the only court he's been to. It's his first time in the 27th, so they went to the wrong court, but they checked in this morning before 9, showing.
All right, you ask the clerk to pull the file. It's up there, Judge.
Aaron Mendez Trevino.
Give me.
Aaron Joseph Mendez Trevino.
Hello.
I'm doing okay. So you need to make sure that you come to district courts first, okay?
Yes, ma'am.
All right, so where are we on discovery?
We went over that today, Judge. It's our first setting. I'm double checking. We have everything. We're also in discussions about a possible ETD. And so all of that's going to be exchanged before the next thing.
All right, Ms. Ferguson, I need a 30-day reset.
Yes, ma'am. It'll be on March 24th.
That works.
All right, just sign the reset form. Once you sign the reset form, you're excused. Thank you for addressing appropriate report. You're welcome.
Judge, may I approach the bench?
I call the cases in order.
Okay.
Yes. What page is Trevino on?
He's on page 5.
Thank you. Jorge Guevara.
I have not been able to locate him. He's not present this morning.
All
He's
right.
not out there either. Judge.
Thank you. All right, court is calling 2024 CR 012217 State versus Jorge Alberto Cuellar Guevara. Could I have parties announced for the record for the state?
Jason.
Defense?
Orlando Castellano.
All right, this hearing was scheduled at 9 a.m. It is now 10:58 a.m. The defendant never answered docket call. Deputy Laura, did you make an announcement for the defendant?
Yes, Your Honor, he is not out there.
All right, defense, have you had any contact with your client?
I have not, Judge.
All right, state.
State requested bond forfeiture, Your Honor, or judge.
All right, the court will grant the state's motion for a bond forfeiture. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
Thank you.
And Judge, he's on the PR bond.
Oh, he's on a PR bond?
Yes, ma'am.
A PR bond for this offense? Okay.
Yes.
We're back on the record. The court will issue a judge's warrant and remain without bond. Charles Claycomb. Court is calling 2024 CR 009592, State of Texas versus Charles Claycomb. Could I have parties announced for the record?
Dwight Chumley for the defense.
And are you Mr. Claycomb?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No.
Mr. Claycomb, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
I do, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, sorry.
Oh, that's a problem. State, are you proceeding on the indictment as presented?
Yes.
All right. Mr. Claycomb, did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes.
All right, you're charged with theft of property, $2,500, less than $2,500 with 2 or more previous convictions of a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
I do, Your Honor.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
I will, Your Honor.
Did you understand that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Claycomb, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 15 months in the state jail facility. State will take in consideration 2025 PF 02867. Did you understand that to be the plea?
Part of it, yes, ma'am.
Well, when you say part of it, what do you mean?
I meant that extra part, yes, ma'am, that they was gonna be put on there also.
Yes. So did you understand that to be the entirety of your plea bargain agreement? Counsel, is that the plea?
Yes.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there being such motions?
No, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
No objections, Judge.
State, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
No.
Oh, yes. Yes, he did.
Yes, I did.
I'm sorry.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. And I'm sorry, what was your plea, counsel?
Guilty.
Guilty?
Your Honor, I would, on behalf of my client, he'd asked me to share this with you, and he is very remorseful. He suffers from addiction. He has HIV because of his drug use. He is 62, and he just wants you to know doesn't want to be a thief. He just found himself in a very bad cycle.
All right, so Mr. Claycomb, you're gonna have to make sure you change things. Otherwise, you're gonna find yourself spending a lot of time in the prison or a lot of time in someone's jail. There are plenty of places that can help you if you want the help, but if you don't reach out, nobody will know your problems, right? Okay? All right, so the court will find you guilty, sentence you to 15 months in the state jail facility, give you credit for any time served. I'm going to take in consideration 2025 PF 02867, and I'll recommend the therapeutic community for you to help with any issues that may need to be addressed. I do not have the jurisdiction or authority to force them to place you in the program, but what I can say is it's going to be in the judgment, and you'll need to request it as well. You understand?
I think so. Yes.
All right. And when you are released from the state jail facility, if you cannot find a place for treatment with your medical issues or with your drug addictions, if I'm still here, you can come back here and I will pick up the phone and get you the help you need. You understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Claycomb.
Thank you, Your Honor.
You're welcome. 15 months. Vanessa Portelos.
I think about you every time I see one of those commercials for Vervo.
Oh, yeah.
You know the ones I'm talking about?
Yes.
It's a good commercial.
Oh, it is. Let me see. All right, so where are we on discovery?
Judge, this is our first appearance post indictment. Ms. Portalis wants an opportunity to come to my office and review the discovery so that we can fashion a way forward in her case.
All right, state on Portalis, you'll need to be prepared to tender an offer at the next setting. All right, and Ms. Ferguson, I need a 30-day reset.
I can do that one on March 23rd.
March when?
The 23rd?
All right, so it'll be March 23rd. Once you sign the reset form, you're excused. Thank you.
Thank you, Judge. May I be excused once we do the reset form?
Yes.
Thank you, Judge.
Sorry, Judge, I meant March 24th. But the 23rd is a Sunday.
Well, I mean, they can be here on a Sunday.
I'm on pass.
Ma'am, you can have a seat. He'll take it to you in just a few moments. He's just a few minutes.
That's a Monday.
Dylan Jacob Skinner.
Thank you so much.
Thank you.
Morning.
Good morning.
Good morning. Yes.
So we have an agreement, we have signed the paperwork, it says, when that sign an application. The complainant, who's Dylan's mother, wants to make a victim impact statement at the time.
All right, so I'll take the plea and then we can reset it for that.
That's fine. Judge.
Okay, we could do it that way. Yeah, we have the
Sure.
paperwork for this.
Okay.
Thank you.
All right, thank you. They have paperwork on that case.
Yes.
Nilda Cabello. Yes.
I represent her. I got her appointed about 3 weeks ago, no contact. She's not here today and she has an active warrant.
All right, let me see if the active warrant is on this case.
I believe so, posting that.
All right, let me see.
A lot of verified, she had a warrant. Yes, Judge.
On this one?
On this case.
And she's not here, Judge. Nor in the hallway anyway. Let me just verify that.
Yes, because I don't see it on the system that I'm looking at. Just one second.
Yes, I see you. Yes, it's an active.
All right, is that what's showing on your system?
Yes, ma'am.
All right, you are excused.
Thank you, Your Honor.
Which do you see like the little lock? It's a little lock on the left hand side.
I looked for it. I'll double check. I'm going in now.
I can get that from you.
And which side is the lock supposedly on?
On the left hand top where it says jail, there's like a
J.
little flag.
It's a golden lock.
Oh, my lock is not golden.
Just hover over it and it should show you. It's on the summary tab.
Oh, that's where I am.
Oh, yeah.
All right, we'll see whenever she gets picked up. Thank you. And what page is she on?
She's on page 6 at the top.
All right, thank you.
Yeah.
Can I just come back?
Can you come back on at 1:30, Judge?
For who?
Kyle Stone.
Are they not ready on him or?
I'm running around, Your Honor.
Sure.
All right,
No
thank you,
problem.
Judge. I'll be back
Yes.
this afternoon.
All right, thank you. And Norma, on that last case, do a remand without bond. Alexandria Alvarez. Hi. All right, so we're supposed to be here today for contested?
Yes. Excuse me. But
All right, so I have a motion to withdraw. Why? Why is there a request that the motion be withdrawn?
Violation allegations, and Ms. Alvarez will agree to the amended conditions.
just completed the parenting class. That was a subject of one of the violations.
All right, so what is going to happen with this case? I don't like for cases to end up somewhere else. So the new #1 allegation that was in the motion to revoke, what's happening with that case?
Happening with your pending cases in Guadalupe County. When's your next court date on those? Next court date is March 6th.
All right. So you all are leaving that case out there to be handled by someone else?
I am not retained on that case. She does have a court-appointed attorney on the Guadalupe County charges.
All right, and what conditions are being, what is she being alternate amended to?
So my understanding is that she is to take a theft level 2 course along with the moral recognition therapy.
All right. All right, thank you. Yes,
Those are just the recommendations from the probation officer.
all right, so why are we recommending that?
So give me just a moment.
Is it based upon the new number 1?
Yes, sir.
Okay, all right, then the court will sign the motion to withdraw. Is there anything else?
Nothing further.
All right, do you have any questions about anything? You seem a little bit confused.
No, I'm sorry, no.
No problem.
I mean, I'm very thankful that's happening.
Okay.
Judge, do you want the amended conditions?
Well, the alternate amendment, the moral recognition therapy, she can do one or the other. Either you can do the theft course or you can do the MRT.
So that option remains open to her. It's not set. in
Oh, right
stone.
now. It's going to be set right now.
Oh,
So
okay. So which one would you rather take?
the MRT is to help you with your thought process, basically something that we all should have learned to choose right as opposed to wrong. For example, if you see money on a counter and you know it's not yours, yeah, you should pick it up and try to find the rightful owner or turn it in to the right person. MRT will help you determine that. As opposed to picking it up, keeping it, putting it in your pocket and hoping nobody will ever know that you took it.
Let's do that.
All right, so Ms. Abrams, just alter amend conditions to include MRT for the burglary. That's, I guess, in misdemeanor court. They'll probably address the theft course with that.
Judge, on both of her cases here, we want the MRT.
Yes.
Thank you.
And who's this?
Excuse me. Thank you.
Thank you. All right, thank you.
All right.
You just need to remain here for conditions.
Okay.
All right, thank you.
Thank you.
Here on Benito Vasquez.
This is not the case. It's not open.
Benito Vasquez.
Moving to another court real quick, but that defendant took off.
Okay, well, we'll take it up when he comes back. Daniel Montoya.
That's party day.
He's coming. He had to he was charging his leg monitor. So
So why was he late for court?
I don't know if he was late for court.
The lifetime, they decided
Oh.
to run it, I'm at the lifetime choke to
Okay.
the program, and
Mhm.
they decided to come whenever they wanted to.
Okay.
So I didn't know he
Alrighty.
was even late, so I
Oh, no,
wasn't
he was
here.
late.
Yeah, he gets a ride from Lifetime. Nobody can go pick him up. Just part of the program that he's in.
All right, today's plea deadline date.
Yes, Your Honor, today we did receive another offer and we countered on that offer. And we would just like additional time, Your Honor, because it may involve him going to prison, and he's in this really good program, which he finishes March 17th. 17th, correct?
Yes, ma'am.
Okay.
All right, Norma,
Yes, ma'am.
recall this for February 24th. That's the final plea deadline date. It will not be extended any further. All right, thank you. Once you sign the reset form, you're excused.
Hey, Carl.
Good morning. I'm ready on issue for Ruger. I want to read all our. Thank you.
Yes. Help when the ones I'm finished with, I will just put them down.
Oh, no, she's putting them in the box. Oh, keeping track of them.
Is on. To make sure that the trip so she's going to jail right now. The bites are all
Jaya in the back. Jaya?
Gaia.
Yeah.
I'm sorry.
The other clerk.
All right, thank you.
All right, who's the officer on this?
So, what is your name? All right, it's all true and correct in the universal law. So when you sign, you need to also print your name.
Oh, yeah. Oh, I'll put Yes, sir. Are you ready on that? I'll leave it right there. She'll get with you in just a few minutes.
Yes.
Thank you. Bye, Arlene.
Just make sure everything is signed before you leave. Thank you. Ulysses Benitez. Court is calling 2024 CR 010834 State versus Ulysses Gloria Benitez. Could I have parties announced for the record for the state?
Your hand, Your Honor.
Defense?
Carlos Martinez for the defendant, Your Honor.
And are you Mr. Benitez?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, I did, Your Honor.
A court will find that the state is in compliance with discovery. Probation, this is an application. Mr. Benitez, did you review the document entitled Application for Deferred Adjudication? Anything else? All right, thank you. With
Yes.
your attorney, did you understand it and sign it?
Yes, ma'am.
All right, off the record for a moment. So I know this is the trial court certification of defendant's rights to appeal. It'll need to be in English.
I have it. It's supposed to be very good.
Okay.
I usually do both from on the subcon.
Ah, all right, thank you. All right, Mr. Benitez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
I did, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Benitez, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge by indictment with possession, manufacture and delivery of controlled substance, penalty group 1, 4,200 grams, that's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was, Your Honor, and he is.
Mr. Benitez. Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
No, ma'am.
All right, counsel, did you have a chance to speak to an immigration attorney or have your client speak to an immigration attorney?
Yes, Your Honor, we've done both. I did, and then they did appoint Tulos. And he spoke to him last week, and he did provide a letter. And then he fully understands. Under Padilla, Judge, I'm obligated to tell him about his immigration warnings and possible consequences before he enters the plea, which I have, Judge.
All right. Mr. Benitez, do you understand the impact a plea in this case will have on your immigration status?
Yes, ma'am.
Do you understand by entering into a plea on this case, you will be deported?
Yes, ma'am.
And do you understand that you will be denied naturalization?
Yes, ma'am.
And do you understand that you will be denied re-entry into the states?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. State recommends community supervision. They're taking in consideration 2024 PF 24733. And there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Ma'am.
Defense is at the plea?
Yeah, it is.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation and 250 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Defense has no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Do you wish to proceed with sentencing?
I would prefer, Your Honor.
All right. Is there anything you wish to say but in regards to the application for deferred?
Your Honor, I have spoken to the mom and the brother. He comes from a good family. He's just, and after talking to my client, Judge, he's worked all his life. So he says, you know, it was lapse in judgment, some easy money, but it'll never happen again. I've learned my lesson. He says all the right things, and his mom is devastated over this because he's got several brothers, Judge, that are hard workers also and have never gotten it.
All right, this is what the court is going to do. The court will deny your application for deferred adjudication. The court will find you guilty, sentence you to 10 years in the prison, suspended and probated for 10 years. Take in consideration 2024 PF 24733. There's to be restitution to SAPD for drug testing. There's to be no re-entry into the United States. There's to be regular reporting by Zoom or in person, regular random UAs. There's a $2,000 fine that will be probated. Do you understand you're not allowed to come back to the United States?
Yes, ma'am.
If you come back to the United States, that will be a violation of your probation and you're facing 10 years in the prison if you do that. Do you understand?
Yes, ma'am.
Probation, he's not allowed re-entry back in the United States. Are any other conditions needed? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You're welcome. Thank you.
Those were the press cough drops that I think.
Oh, if you need any more, we have some.
You know, it's, I was doing this and those are a lot.
Ah,
Thank you, Judge.
you're welcome.
You have a good one.
All right, you too. State on Benitez, do you have the case to be taken in consideration? All right, thank you. Yes.
Yeah.
Mhm.
I'm back.
Sorry, Judge, when's he sentenced?
Yes.
Oh.
Yeah. Yes.
John, I'm back on Benito Vasquez. Your Honor, you had called this case. I turned around, he wasn't in the courtroom. I went out in the hallway to check on him. He's gone. And so this is not a compliance hearing, Your Honor.
All right. Let me.
I talked to him earlier in the morning. He was gonna make a call to his wife and come back to the courtroom, and I haven't seen him since, Your Honor.
All right. Well, I will make a ruling Just one moment. All right, so on this one, I'm gonna issue a judge's warrant. And your client will be remanded without bond.
Lito Vasquez, Lito Vasquez.
All right, thank you.
Excuse you.
Yes. Benito Vasquez?
So you just called that one, Judge called it.
Oh, no, that was a different Benito's Vasquez. That was Ulysses.
No, Mr. Collins, you told him he can leave it on.
Oh, that is this one. Oh, okay, thank you.
I think the other one's beneath this. I couldn't, yeah.
Okay, that's that one. All right, and let me see what page he is on. He's taking up a lot of the docket.
On page 7.
All right, thank you.
And page 8.
Didn't I complete Alexandria Alvarez?
They wanted to reapproach on that, Judge.
Yes, Alexandria Alvarez.
And Judge, according to Yaya, they're asking for the GPS to be removed today, but there's no paperwork stating that.
Okay. All right, so once the motion is filed, I'll take it up. So
Okay.
whenever you all file that motion, I'll hear it.
Well,
Oh,
it's
the
part of
GPS.
the bond, and that's my understanding, is that with the altered and amended conditions, that cancels it out, doesn't it? And then she's free to have it
Not
removed.
necessarily. I'll need to see the paperwork on that. I don't have any paperwork with regards to that being a condition of bond. If you have them pull it,
That
I'll
was
review.
something that you had imposed when she had come to turn herself in on the 6th, and
Yeah,
then we had,
no, if you all will have the clerk
okay,
pull the order, I'll review it.
all right.
Okay.
The order
from the last time that she
Yes.
was modified to tracking only.
Yes.
Okay.
All right, Dylan Skinner.
Okay.
Which would be up here, ask the clerk in the back.
Dylan Skinner. Who's the attorney for Dylan Skinner? All right, court is calling 2024 CR 011052, State versus Dylan Skinner. Can I have parties announced for the record for the state? Defense?
Brian Kimbrough for Mr. Skinner.
And are you Dylan Skinner? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No.
All right, Mr. Skinner, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Skinner, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to enter into a plea and give up those rights in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Skinner, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The state is taking in consideration 2024 CC 739463. There's an affirmative finding of family violence, and there's to be no contact with Dusty Skinner. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea? Defense, is that the plea?
That is.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? You're gonna need to speak up. Counselor, there been any such motion?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No
Any
objection.
objections? Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Can you repeat that?
I'm so sorry. Did you understand you have a right to jury trial?
I do.
All right, so that would mean that 12 people would sit in the box and they make a determination on whether you're guilty or not guilty if they could come to a decision. Do you understand that? Do you understand that if you were in a jury trial, the state could not force you to testify? That's your right. You don't have to testify. Did you understand that? Did you understand that the state would call witnesses, and those witnesses, if your attorney chose to or you chose to, could be questioned by you or your attorney? Do you understand that? All right, by entering this plea bargain agreement, you're giving up those rights. Did you understand that?
Yes, ma'am.
So today, with regards to these stipulations, the state is not bringing any witnesses in. They're asking the court to just review the police reports and witnesses' statements and make a decision on whether or not there's sufficient evidence to find you guilty. Do you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. And whenever you need me to slow down, just let me know, okay?
It was just that one that you said.
All right, but if you ever need me to slow down, just say it.
You don't
Let
have
me
to
just
slow
tell
down.
you, a court reporter would appreciate it if somebody says, slow down, Judge.
Right.
All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. And off the record, counsel, I know that you and the state had come to an agreement that the complainant wished to give a victim impact. All right, is she able to zoom in? All right.
And if the court would give us just a moment, we could see if that would be possible.
Are you okay with them
We could
checking?
do it this morning, yes.
Yes, all right. If you can see if she can zoom in. All right, thank you. Jason Moore, court is calling 2025 CR 0000924 State versus Jason Moore. Could I have parties announced for the record for the state? Defense? And are you Mr. Moore?
Yes, ma'am.
Probation, this is an application. Did you review? Counsel, I'm sorry, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moore, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Moore, did you review the court admonishments and defendant's waivers and affidavit of admonitions with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault on a peace officer as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state could call, and the right to remain silent. Do you understand?
Yes.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Are there any such motion?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, community service hours, mental health assessment, no harmful or injurious contact with Barbara Dunkel. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead?
No.
State, any evidence?
Did I first exhibit number 1 and
No objection.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, Your Honor, yes.
Anything you wish to say on behalf of your client?
We hope you follow the plea agreement, Your Honor, and he's been on med since he's been in jail, since November 1st.
All right, and who is Barbara Duncan?
Mama.
No, I'm asking him.
I'm sorry.
All right, so why is there why is there a no harmful or injurious contact? Was there any type of case involving her?
There was this, I mean, I don't know what his living arrangements are, but the evidence that was stipulated to, I think, supports that, even though that case was disclosed out.
All right, what are your living arrangements?
I currently live with my mom, taking care of her physically, and she's got a bad angle, bad hip, so I kind of watch over her. If she's okay, take care of the house.
All right, isn't there a home health care provider to do that?
She doesn't have one. She's actually trying to get surgery and everything.
All right, because I don't allow people to be home health care providers. So if you're trying to segue into being her home health care provider, it's not allowed in this court.
He's gonna get a job.
All right, so I'm asking.
I'm sorry.
So when's the last time you had employment?
Right before this.
Doing what?
Aircraft mechanic for civil service, United States Air Force.
So what happened on this day? Why did this all occur?
Can I answer?
I want to know from him. He's the one, you can answer if you're going to be on probation with him. So, all right, so what's going on that day?
I was just currently I had no sleep for a little while. I was on Ambien. It's a medication.
I know, I understand Ambien.
With my condition, I was.
So have you ever had any mental health diagnosis before?
I have. Yes.
All right, for what?
Bipolar.
All right. And do they have you on medication at the jail?
Yes.
And what is that?
Axel.
Mhm.
And a shot of, they call it Abilify.
All right, and do you have any type of case manager or somebody to help you continue with your medications if you're released from custody?
I was on medication before I came with the VA. I get the Veterans Affairs.
Okay. All right. And did anybody check to see if Veterans Treatment Court would accept him in their program?
No.
All right. Do you want to consider being under the umbrella of Veterans Treatment Court?
Many things.
And Norman, no more
Okay.
cases.
I'm satisfied right now. Just the program. Yeah.
Do you know anything about the Veterans Treatment Court?
Do not.
All right. This is what the court is going to do. There's $1,000 fine that'll be probated. The court is going to sentence you to 4 years deferred adjudication.
Four, not three.
Oh, that's outside the agreement.
I know, but I'm just making sure you knew she recommended three.
Yes.
Okay.
All right, Ms. Abrams, can you see if somebody from Veterans Treatment Court can come up and speak to him? All right, so 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, a referral to Center for Healthcare Services or the VA. There's been no harmful or injurious contact with Barbara Duckle. There is to be 60 sober meetings in 60 days.
With who?
They'll tell him.
Okay.
Yeah. 150 hours of community service restitution. Do you have any children?
Yes.
What are their ages?
17 and 20.
All right. And are there any minors living in the house with you and your mother?
No.
All right. So there'll be 150 hours community service restitution. I'm going to order anger management. Once he completes anger management, 100 hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Somebody from Veterans Treatment Court will come up here and speak with you. Maybe you will decide after talking to them, you want to be considered for the Veterans Treatment Court. If you do, I'll grant your defense counsel motion for new trial if that's what you decide. Otherwise, they're going to come up here and they'll speak to you so they can make sure that you're connected with the VA. You understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Have a seat, sir.
All right, Dylan Skinner. Yes.
Yes, Your Honor. It seems that she is not, she has to write her statement, et cetera, et cetera. Also, if we could just reset the sentencing portion, he wants to make an apology to his mother. And
All right, we can recall it for the, Norman, can we recall this for the 24th or 25th? All right, we'll recall you for Monday.
Thank you. Your Honor.
Thank you. Yes. Okay. Yes. Yes. Timothy Gonzalez.
We're gonna do
Thank you.
Hello.
it.
All right, so they're dismissing your case. They say that is for insufficient evidence.
Thank you.
All right, thank you. Have a good day. Thank you for always dressing appropriately for court.
Is Timothy Gonzalez, correct?
Yes. Red wine, Angela Red Wine. See, what did I say? People always think the inmates are, you know, a great dating pool. I guess it's a great dating pool for them to be faithful to you, but.
What are you talking
I don't know.
about?
Well,
What is
no,
she talking-
somebody was still trying to talk to inmates. I don't know why. Yes.
Yes.
Can we have the case recalled for Monday?
Sure.
Okay.
All right, and could you let your client know not to be talking to people in the audience?
Okay,
All right.
thank you, Judge. We'll be back on Monday.
All right.
Thank you. Appreciate it.
See, John, you were wondering, who was I talking about? It's your client. You're welcome. Matthew Boggs? Bags? All right, who's the attorney for Matthew Bags? All right, just have a seat. Your client's not here. I'm sorry, your attorney's not here.
He's right there.
Bags.
Mr. Stenberg. Mr. Stenberg. Come up, they're calling your client.
Thank you.
Yeah, I've had the trouble all day with him.
Hello, are you all ready to proceed on this case? Are you ready to proceed on this case?
Oh, yes. Yes.
All right, can I have a file stamp? For a motion to revoke? Court is calling 2024 CR 2163, State versus Matthew Bags. That party is announced for the record for the state.
Opinion for the state of Texas.
Defense.
Joe Stenberg.
And are you Mr. Bags?
Yes, ma'am.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Are you the same Matthew Charles Bags who was placed on deferred adjudication in 2024 CR 2163 for the offense of repeated violation of court order or bond condition on June 11, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, sir. So proceeding on state's first amended motion to enter adjudication of guilt. Violation condition number 1. On or about the 20th day of January 2025 in Bear County, Texas, the defendant, Matthew Charles Bags, committed the offense of violation of bond protective order in violation of condition number 1.
How do you plead to that? True or not true?
True.
Seeking waiver of other violation.
Any objection?
No,
Any
Your Honor.
objections to the waivers?
No.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, it is for 3 to do.
All right. So with regards to the condition, violation of condition number 1, who is the complainant in that? Is it the,
Same victim as in the current case.
all right. Anything you wish to say on behalf of your client?
He realized the error of his ways. And he accepts 2 years to do.
All right, here you go.
Thank you.
Is there anything you wish to say to the court?
I'm sorry.
All right. Court is finding violation of condition number 1 true. Court will find you guilty. Court is going to sentence you to 6 years in the prison. Give you credit for any time served. There's to be no contact with Rosalind Marie Fernandez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. When I say no contact, I mean no contact. You're an adult. You should understand you're not to have contact. You understand? All right, good luck to you.
I have no idea. She has to follow and she's going through whatever she gets.
Okay, I have no idea. It's just like, okay, I think that's a way of making it.
We'll just wait. I mean, what page is Boggs on? Our bags?
It's on page 11 at the bottom.
Thank you. Who is here on, Renee Esparza?
Occupational license.
All right, so we're gonna have to have a hearing on this. Are you able to come back or be by Zoom this afternoon?
I have a plea at 1:30 and come out, but what time do you think?
Oh, just zoom in when you can zoom in. We'll be here.
Okay.
All right, and then if you want your client to be by Zoom, he can be by Zoom as well.
That'd be great.
All right,
Okay.
and Ms. Ferguson will give you the Zoom link.
All right, thank you.
Just take a photo of it. It's right there. The 824.
Kendall Smith?
President, Your Honor.
I think so.
Court is calling 2024 CR 012136, State of Texas versus Kendall Smith. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
For the defense?
Renee Munoz for defense.
And are you Mr. Smith?
Yes, ma'am.
All right, counsel, have you received all discovery? Did
Yes.
you review it with your client?
Yes, Your Honor, that is correct.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
All right, Mr. Smith, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor.
Mr. Smith, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is competent and ready to proceed, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 134 days in the Bexar County Jail under 1244. There's a $500 fine. And there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is correct, Your Honor.
State, is that the plea?
Judge, I wanted to know, 74 days.
No, it's
Yes,
134.
134.
134.
So it's received?
Mhm.
Yes, I have one.
All right, thank you. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objection.
Right. Did you review the document entitled Waiver and Consent to Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Yes, ma'am. Did you understand that today the state will be presenting evidence in the form of witness statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're requesting that the court follow the negotiated plea agreements. My client is homeless. However, at this point, he is working a program through jail outreach at Haven for Hope. And he's doing quite well there. He's addressing a lot of the issues that have caused him to be in front of the court today. So we're requesting respectfully that the court follow the negotiated plea agreement, Judge.
All right. And is this does he have any priors?
Prior offense to. Yes, yes.
Okay. All right. And are these prior felony convictions?
No, misdemeanors.
Misdemeanors for what? All right. Let's go off the record for a moment.